wouldn't have happened. You know, we don't have that ability.
I think the one thing in South Africa we need to get used to, Salome, is the fact that we need to share resource and make sure we maximize every.
Absolutely. Absolutely.
Good day, everyone, and welcome to this webinar. I'm just making sure from the IT side that we are going live. Kurt, can you just confirm that everything is ready to go?
Yes, it's live.
Thank you very much. So welcome everyone to this webinar, which is being hosted jointly by UKZN and the Cancer Alliance. The title of this webinar this morning is Inequities in Access to Cancer Medicines in South Africa. And it is being hosted by the World Health Organization Collaborating Center for Pharmaceutical Policy and Evidence-Based Practice, as I said, together with the Cancer Alliance. There cannot be a more sensitive topic, perhaps, than access to cancer medicine. There is no more vulnerable population than those who are facing cancer. And access to effective treatment is absolutely key to their success and to their survival. So the ways in which governments and health systems ensure the affordability and accessibility of cancer medicines is absolutely critical to the functioning of those health systems. So I'm going to have a number of speakers this morning. We have, as you can see on screen at the moment, a number of panelists. Salome Meyer, who's Project Manager Access to Medicine Campaign at the Cancer Alliance. We've got Dr. Ki Sanchez from the World Health Organization from the Medicines and Health Products Division. We have Professor Fatima Suleiman, who is the head of the Collaborating Center and is a professor here at the University of KwaZulu-Natal. Then Fatima Hassan, who is the director of the Health Justice Initiative, a very well-known health access and medicines access activist in South Africa. And finally, Marumo Nkomo, who is a director at the Department of Trade, Industry and Competition, and has been absolutely key to the way in which South Africa is addressing intellectual property law reform. So a range of speakers, a range of opportunities for you to learn about the issue of cancer access. But what we will do is have each of the speakers in turn, and that should leave us time at the end for questions from the floor or questions between the panelists. So it therefore gives me great pleasure to start off with the first presentation, which is going to be by Salome Meyer. And let me just make sure that you can see her slides. Those should be up ready for you. Salome, as I said, is from the Cancer Alliance, and it is their report on access to cancer medicines in South Africa, which has really been the key, the starting point for this webinar. Salome, over to you.
Thank you, Andy. Thank you for everybody joining this very important moment for us as the Cancer Alliance. Certainly availability and affordability are the two key determinants of access. And in our report that we have recently published, we actually explain what we mean with that. Nelson Mandela coined it and said, health cannot be a question of income. It is a basic human right. Thanks, Andy. Next slide. So that in itself, already we have started with that narrative many years ago with regards to HIV/AIDS. It is now time for us now that we take that narrative further. And in fact, COVID has actually highlighted that very particularly, where we actually see the very inequities in health in South Africa, and then particularly in low middle income countries. Next slide, please. So our first report that we reported on was in 2017, where we particularly highlighted the patent status and length of certain cancer medicines. And in that report, there were 21 medicines that were available in the private sector. However, only 7 medicines were available in the public sector. 10 of those were on the WHO essential medicines list. Now, subsequently, at least, we now have 8 medicines on the South African medicines list. Included in those are trastuzumab, bortezomib, and thalidomide. However, we still have the issue that prices block equitable access and leads to excessive pricing. Next slide, please. So in our second report, we focused on the public sector as well as that of the private sector. So the public sector, we know there's a tender system that is applicable for the public sector in terms of procurement, and that runs over a 2-year period. And normally the Department of Health will start with the tender advertising in the September of the previous year, when the tender kicks in about July then of the following year. So for the last 2 tender cycles, that means 4 years, we have had very particular problems in the tender system. And that in itself is causing a lot of patients not to actually have access to their cancer treatments. We don't even talk about out-of-pocket expenses. In the private sector, however, we have the same medicines that are used in the public sector, and of course, pharmaceutical industry preferring to supply the private sector rather than the public sector, because according to them, the private sector pays quicker than the public sector, and we know that that's not necessarily true. We have the situation also that there's overpriced specialized medicines. The question with regards to specialized medicines are also whether those medicines are in fact actually adding to the quality of life and will really change the situation for cancer patients. And that in itself comes in with the question of value-based care. I think for me now, because the other 3 speakers are going to address the other issues relating, or the other 4 speakers particularly are going to speak to some of the aspects within the report. So if I can have the next slide, I would like to focus on what our key recommendations are. So for us, cancer registration is very important. There is a regulation already promulgated in 2011. However, that regulation does not make the person that diagnosed cancer responsible. At this stage of the game, it is the head of the facility. We all know what happens with delegated authority. It gets delegated down to such a level that nobody actually does it. And that, in fact, is one of the problems. We need to also very critically look at the promulgation of the regulations pertaining to bonusing. Very interesting, the Department of Health actually published those draft regulations in 2017. It's now 2021. Nothing has been done to that. That needs to get very urgent attention. We also call on the Department of Health to do pricing policy reform. And both Ki as well as Professor Suleiman will actually also touch on the types of pricing policy reforms that is required in South Africa. With regards to Treasury, thanks Andy, the next slide. With regards to Treasury, then we will say that cancer medicines, and in fact it's actually medicines, cannot be equated to the same as public goods or whether you buy photocopying paper. And that is actually what is happening currently. It is equated with exactly the same principles. We're not saying throw it out the principles of the tender regulations, but what we are saying is maybe it is time that we revisit those tender regulations and actually look at specifically what is blocking access to for critical medicines. We also say that the oncology market is too small to have two systems for procurement, where the private sector takes preference with industry. The oncology market in South Africa is only but 1% of the market. And what we do know is, as a fact, is that the public service 84% of the population, and the private sector then therefore the remaining. However, we have a far better procurement system within the private sector. And that in itself is something that we need to address. So we need to kind of like look at how we're going to do that. From next slide, please. The DTIC, and I really do hope that Marumo is going to come with some good news for us. We really need to finalize that patent law reform process. We have particularly seen with one of the last medicines that has been added to the South African EML, namely bortezomib, that specific medicine in South Africa does have a patent. And at the moment, the generic company that has got a generic available cannot launch their product because of the specific patent. And we are releasing today a video regarding to that on the Fix the Patent Law website. We have seen also in South Africa that the effective use of competition law has not necessarily been in place. There's been two cases in South Africa where we've used excessive pricing. And the first one was the Hazel Tau case. And now, secondly, the one that has not been finalized is the one with Roche and trastuzumab. We're still waiting for the outcome of that. Certainly, we need to start looking at how we can expedite these inquiries. And then the National Planning Commission in their report already alluded to the fact that there is needed an inquiry into the pharmaceutical industry in the same way that there was an inquiry into private health. So that is also something that really we would call for. Next slide, please. Then with regards to SAPRA, there's many things we can say about SAPRA. We also know that they are working under tremendous strains, particularly now within the COVID area. But what we need to look at with SAPRA, we need to look at the affordability of Section 21 medicines after registration. The lenalidomide case is very interesting. So lenalidomide was a Section 21 medicine for a number of years, at least 3 to 4 years. And at the time of availability, the medicine was available at 5,000 Rand. That is the generic products. Subsequent to the registration of the generic products, those same products are now available for 20,000 Rand. Now that in itself is also something where we say to the industry, we're talking about access, we're talking about affordability. The Department of Health cannot afford a 20,000 Rand price tag to add lenalidomide to the essential medicines list. We also then call for the registration of key cancer medicines sooner than the normal 2-year process. We know that there's a backlog process in place, but still, we need to look at that. Next slide. And then we say to industry, we need to have the consensus. The recent Fair Pricing Forum actually also concluded that that debate is something that needs to happen. And I think that would be brilliant if we can start the debate in South Africa. What do we mean with actual fair pricing in South Africa? For the funders, yes, the cancer benefit packages, we need to look at what are the out-of-pocket expenditures that people have. Then we have a recommendation, the next slide, please, Andy. Then we call for an online portal, an online medicines portal that is open, transparent, and also collaboration between SAPRA, the National Department of Health, the DTIC, that's where you in terms of patent registration, as well as the industry that is managed in real time. It may sound like pie in the sky, but these kind of systems are already researched, and in some areas it's already in place. It is time that we again research how can we do that and how can we look at funding something and managing this collaboratively. Our last slide is then what we as the Cancer Alliance is saying is it is time to rethink, to redesign, and to re-engineer. Specifically with regards to cancer medicines, we are saying that particularly because the cancer pharmaceutical industry is so small in South Africa, however, it affects so many people in South Africa. This is a perfect opportunity in going forward into the NHI that we can take this as an example and see how can we structure the concept of rethink, redesign, and re-engineer. We look forward to that debate so that we can ensure that we leave no one behind. Thank you.
Thank you very much, Salome. Now, I probably should have introduced myself at the beginning, but it does give me the opportunity to say that I'm Andy Gray, I'm one of the co-chairs, but I want to give Mark Haywood, who's been scooting around Johannesburg looking for electricity, a chance as editor of Maverick Citizen to give us just a few words about the subject of today's webinar. Mark is going to be co-chairing with me. Mark, over to you.
Good morning, everybody, and my sincere apologies for being late for this really very important webinar. As Andy said, I was sitting peacefully at 9:15 this morning, having checked load shedding schedules when the lights went off, even though there was no load shedding scheduled. So I've just rushed from Pretoria to Johannesburg to an office where I know there's a generator to be part of this important webinar. So I apologize for being late. But I'm very happy to co-host and to help moderate this discussion. I think that COVID-19, as one of its side effects over the last year, has been to obscure many other important health challenges that we face in our society, and in fact, to disrupt many other healthcare services. And we're really only just beginning to come to terms with the consequences of those disruptions. So to turn the spotlight again onto another cause of illness, another cause of mortality is very necessary and very important. It's also important because COVID-19 is now very starkly making us aware of the inequalities that exist in health systems, particularly around vaccines. But I think, as all of us know here, these inequalities are not new. They have existed in relation to other essential medicines, and access to medicines for cancers is a prime example. As Salome explained, and as the important reports that the Cancer Alliance has just issued sets out, there are many breakthroughs in science around cancer, in medicine around cancer, that are not being made available because of patents and because of prices. So we have to use the COVID moment to make sure not just access to vaccines for COVID, but access to medicines for all causes of illness. And what I think Professor Gray and the KZN have done for us today is to create a space to discuss these issues, to learn about these issues, and hopefully to put this squarely back on the agenda. So I'm looking forward to facilitating this. I'm looking forward to covering this issue in Maverick Citizen. And it's great to be here with 94 participants and a diverse and informed range of presenters. So thank you very much for your patience. And Andy, back over to you.
Thanks very much, Mark, and thank you for taking all of that effort to find somewhere that had electricity. So one of the important roles that the World Health Organization fulfills is what's referred to as its normative role. So it gives guidance to member states on policies and interventions in the health sphere. Dr. Ki Sanchez is from the WHO headquarters in Geneva, and he is going to update us on some of the normative guidance on medicines policies that WHO has been issuing over time, and that was actually updated very recently. Thank you, Ki.
Thank you, Andy. So let me just project my slides. Okay, thank you very much. Good morning, everyone. Thank you very much for the invitation to speak at this very important meeting, and heartfelt congratulations for the great work. I've been asked to give a global perspective on price and cost of cancer medicines, which are known contributors to inequitable access globally. So in the next 9.5 minutes, I will highlight some findings from the 2018 WHO technical report on pricing of cancer medicines. And I will also cover some longer term work relating to pricing of medicines. WHO is currently working with various stakeholders. So before I do that, I would like to acknowledge the generous contributions from many experts who we consulted in developing this report and guideline, including Professors Fatima Suleiman and Andy Gray. So thank you very much. So can I? Okay, sure. Sorry. So the WHO technical report on pricing of cancer medicines was published in December 2018 at the request of the Assembly in 2017. So this was the first comprehensive report on pricing of cancer medicines and it covered a range of topics, including clinical benefits and risks of cancer medicines, pricing approaches used by the governments and industry, impacts of pricing approaches, including availability, affordability, and R&D globally, and options that might improve affordability and accessibility. So in drafting this report, we had also published a peer-reviewed journal article that looked at the relationship between R&D costs and revenue returns for the originator companies. And in 2019, this report was cited in further WHA resolution on improving the transparency of the pharmaceutical market, which has been widely noted as a landmark resolution. So it is not possible for me to go through in detail with the time available, but I have provided the web links here for your future reference. But I do want to highlight 5 key findings from this comprehensive report that relates to the price availability, affordability.
Sorry, Ki, just a point from our audience. Can you just put this onto slide view, not notes view?
You can see my note. Can you see my my slides, Andy?
I'm seeing your notes. Not
Oh,
your
you're just seeing my
slides.
notes, is it? Okay, I thought you could see my. Okay, so apology for that. Okay, I'll end my notes then. Let me see. Okay. Okay. Can you see better now?
That's perfect.
Okay. I was hoping that I could see my notes when I'm presenting. So anyway, so I do want to highlight these points for you. So from the report. So first, the prices and costs of many cancer medicines are high, both in absolute and relative terms. So in absolute terms, we observe that many people actually, many cancer medicines are now in the at least tens of thousands of US dollars per patient per year. And then in relative terms, we also found that it is much higher than products used in other therapeutic areas. And also historically, when we compare, the rate of inflation is much higher. We also observe that prices are highly variable, both within countries and across regions. And then in terms of the availability, we noted that countries with a lower national income generally have low availability. Generally, lower income countries have to wait for many years before the products will be launched in that market. And when it is available, they usually have higher out-of-pocket costs. So if the products are not covered by insurance, usually they are not affordable for patients. And then in terms of the journal articles that I mentioned before, cancer medicines through high prices have generally generated returns for the originator companies far in excess of the R&D costs and other factors of production. So these have various implications in terms of the R&D landscape. These are some of the news headlines in February 2019 that I've collected following the publication of the WHO report. And interestingly, it shows that there are a lot of concerns coming from a range of stakeholders, so including shareholders' criticisms of Novartis pricing of a particular product. So, and also it no longer is an issue of the lower income countries. It actually has has threatened the financial sustainability of many high income countries, including Switzerland and Japan, as shown here. So it is well and truly a global issue now. The report has presented 6 groups of options that might enhance the affordability and accessibility of cancer medicines. They are interlinked with 24 interconnected policy options. So you can refer to them in the report. But for the purpose of this presentation, I'll focus on 3 options that I think would be most relevant, at least that a global community should focus on. So the first option is to really create competitions among substitutable medicines which respect price, quality, and ability to supply. So in various countries, there have been examples of pricing policies aiming to leverage competitions. For example, they use what is called internal reference pricing. Essentially, what this means is that if the products it has the same effect or similar effects, they should be priced the same way or similar ways. So the listing of some products on the WHO essential list of medicines is particularly pertinent because they're trying to group products with similar therapeutic effects together when they're listing them. So the problem is that in some countries, the prices are actually not linked with each other. So with this particular pricing approach, it could actually address some of the lack of competitions for on-patent medicines. So I've listed some examples here. Of course, there are also other approaches such as well-structured tendering processes and the use of voluntary licensing and applying TRIPS flexibility, which I will not detail here. So in September 2020, WHO also published a pricing guidelines of pharmaceutical pricing policies. Within this updated guidelines, the only strong recommendation is for the promotion of the use of quality assured generic and biosimilar medicines. And this is the only policy with strong recommendations. And for the very first time, we have included biosimilar medicines in these recommendations. Very specifically, we ask countries to really enable early market entry of generic and biosimilar medicines so that they can compete both in terms of price, quality, and available supply. We ask countries to make sure that they use multiple pricing policies to achieve lower price, and the pricing should be informed also by the cost of production. Sometimes we do see that some locally produced products, they actually has very high prices compared to other to the cost of productions. And finally, we ask countries to also consider a range of what we call demand side policies, such as to encourage substitutions at the clinical levels, to ensure that there are financial incentive for prescribers to prescribe them, and also finally to really build confidence amongst the community so that they can actually be assured that these are good quality products, and then at the same time it's going to save a lot of money for the healthcare system. The next group of options that I think will be really important is to enhance system availability to review and adjust prices and withdraw funding for superseded or less cost-effective medicines when required. Too often we see that, I think this relates to the point Salome was mentioned before, that too often we forget that the conditions of a policy has changed tremendously. So there's a policy in place which was fit for purpose at that point in time, but the landscape of the market has changed. So in many countries, we observe that sometimes countries do all the careful works in setting up a price and forgot about them, and then the prices are not revised, so that they no longer become affordable. So the point that we want to raise is really that countries should actually look at the system efficiency carefully, and also try to adjust the price according to the competition landscape. And the second option is really to enforce price caps for medicines with or without progressive reductions of prices over time. So on that point, I would actually want to highlight here the final two paragraphs of the pricing reports. So we spoke that global corrections of unaffordable prices for cancer medicines will require considerable short-term system adjustments. So first, I think we need to recognize that it is a global problem. It's good that countries are doing their own thing. So WHO is actually working on this because it's important that the price are linked in the global markets, and certainly the pharmaceutical industry operates that way. So we are trying to address this issue as a global issues. It's good that at the country level they do what is needed at the local context, but also we need to see it as a global problem now. Secondly, I think that it requires some short-term adjustment, because historically we see that there's a lot of misalignment between the price and the true value of these medicines. For example, because of wrong benchmarks being used. For example, they are not capturing the full opportunity cost. So sometimes we do see that products are assessed and then they say that it is cost effective but not affordable to the health system. And finally, I think we need to actually look at the full cost of the treatments. It's not just the price of medicines, but how the medicines impact on the whole entire healthcare system. So that's another area of work that WHO will be working on. Finally, is what we call dynamic inefficiency. There's always a bit of a fear from people saying that, oh, if we lower the price, we are going to threaten future innovations. I completely understand these concerns, because after all, cancer is still the most one of the largest public health issues we have today. But what I want to say is also that if the prices are too high and it generates a lot of profit, so what in economic terms we call supernormal profits, it can also distort investment, and it is also not good for the innovation system. This is a really big topic, and then we see that in the antimicrobial or antibiotic sectors, they have a lot of this discussion as well. But that is a topic for another day. So on that note, I would stop here. Thank Thank you very much. And apology that I was sharing a wrong screen.
No need to apologize at all. Thank you very much, Ki. That was perfect. So I'm now going to ask my colleague, Professor Fatima Suleiman, who's Professor of Pharmacy here at UKZN, Director of our Collaborating Center, but also a previous chair of the Pricing Committee in South Africa, to give us an idea of the local context of medicine pricing. Fatima, over to you.
Thank you, Andy. Sorry, I'm just going to get to the slideshow. Thank you all very much, and good morning to you all. Thank you for joining us today. I am actually going to be speaking a little bit today about the imbalance of medicine access and possible solutions to ensure equitable access. So this slide presents the age-standardized incidence rates of the 5 most common cancers in women, in men, and in children. It is surprising, well, not surprising, but more shocking to know that 9% of all-cause mortality in adults is due to cancer, but we don't know what's happening with children. And the projections are that actually this situation is going to get worse over the next 10 to 15 years. But it's not just about the incidence that is a problem. It's these costs of cancer medicines in South Africa. There have been lots of newspaper reports and other reports regarding the high costs of medicines, but chemotherapy as well, the whole cancer care pipeline, and also the hidden costs of chemotherapy. As Lomi had mentioned previously, there's the other aspects of cancer therapy like wigs, like transport, like other sorts of care that are required that are not factored into the whole cancer care. But medicines do play a big role in what is the expenses that patients are facing, even those on medical schemes, because you can see out-of-pocket expenses also force patients to go into bankruptcy, and that is a human rights issue as well. So what is the cost of cancer in South Africa? There was a publication in the South African Medical Journal in 2016 that talked about the price tags of medicines. And if you look at some of the new generation immunotherapy medicines, they start at something like 1 million rands for therapy, or 25,000 per treatment cost. Even procedures like mastectomy with the medicines cost a lot of money as well, and it's not sustainable for the public sector, but it's also not sustainable for patients, because medical schemes contributions generally are between 20,000 to 40,000 for the low income group per year, and that does not cover these kind of interventions. A recent study conducted by some colleagues of mine, together with myself, looked at just routine medicines, not even the high cost of immunotherapy agents, but just the normal first-line therapy of medicines and what they would cost in terms of affordability for patients. This first table just looks at the single exit price of the originator products of these medicines, and then the single exit price of the low price generics that are on the market in South Africa at the moment. And you can see that the differentials are actually quite high for most of them, but there are a few outliers and puzzling ones. So for example, in the fluorouracil 500 milligram sector, the low price generic is actually much more highly priced than the originator product. And in some cases, you could see that the generic products and the originator products are actually priced quite closely together. So is the single exit price policy working? Is it an option that we should be considering in future? It has resulted in savings of medicine costs in the country, and research has shown that. But as other monitoring and evaluation of pricing policy studies conducted elsewhere has shown, you cannot have just a single pricing policy in order to be able to ensure affordability and access to medicines. There has to be a combination of policies. If we look at the affordability part of the study, you could look at medicines that were costing something like 32.3 days of wages for this. And we must understand this affordability in the context of the fact that this is from the lowest paid government worker, so not even those that are paid less than that for one. Two, that income needs to be divided among rent, electricity, food, and then healthcare costs. And then sometimes the family has more than one disease condition. So paying something like 32.3 days of wages for one therapy is actually really unaffordable for most people in this country. But even something like 11.5 days or 9 days, even 3 days may be unaffordable as well. So we really need to look at not just the new therapies that are coming or the third line therapies, but the first line therapies and how affordable these are as well for patients in this country. Ki has mentioned previously the report on the pricing of cancer medicine and its impact. And this was something that looked at the sales income of these medicines by different companies and found that actually sales income greatly exceeded research and development costs. And that's why pricing models need to be considered. And therefore, we also need to factor in what is a fair price. The other concern is that with cancer medicines as well, there are new medicines coming out. They are priced quite highly, but actually the gains and the benefits that we get are actually not that great. So should they be priced that much for the small amounts of gains that we get? So we need to re-look at how we reward innovation versus new medicines versus new manufacturing capabilities as well. So what are my recommendations for South Africa? There are three distinct aspects that I will talk about. There is the Section 21 registration that allows for medicines that are not registered as yet or not marketed as yet to be launched in South Africa or used in South Africa. Sometimes these are via clinical trial access. Sometimes these are via market access programs by pharmaceutical companies before launching. But it is problematic because pricing at that stage is not overseen by any statutory council and actually there should be oversight at pricing at that point, because there's a vast difference between pricing at Section 21 registration level versus single exit pricing level. So that needs to be looked into as well. But also what happens post-registration? If you have access campaigns and patients using medicines and suddenly on registration you have a price tag attached to it, what happens to those patients? Should we have a policy caveat like we do for clinical trials that if patients are benefiting on those, they need to be supported until they do not require treatment anymore? And I think that is a human right perspective to take. Other policy options that could be considered are external reference pricing. Now, there are problems in that because there are studies that talk about prices converging globally because we use external reference pricing. But it does allow South Africa to have a look at what's being paid in other high-income countries, not just in low and middle-income countries, because South Africa sometimes pays more for medicines than other high-income countries. Then also internal reference pricing. If we have generics and biosimilars being launched in the country, should they not be priced at a percentage of the originator price? Should we not reward first entry generics with much more of a price hike than others that are coming in later, and therefore faster generic competition? We should also be asking for pharmacoeconomic studies. We should be talking to pharmaceutical companies to justify their high price tag or their prices on launch and to understand exactly what it is they're putting into it. But more importantly, there should be transparencies in those studies as well. If public sector funding globally has been used in the research and development of that medicine, then that needs to be factored in as a discount on the price in these studies as well. So we need to look at the way pharmacoeconomic studies are modeled and how costings are inputted into those models. What are the other options? Now, a lot of companies will talk about what they call value-based pricing, or the claims that these are really good products. But the problems with those sorts of things are, first, they're very labor intensive to set up. They're very resource intensive to set up. Many countries have found it difficult to actually get back money after these arrangements are made, and results sometimes from patients occur long after use and payment. So it's not so easy to do that. What about options for patients who cannot afford it? Do we need better purchasing and negotiation on the public sector side? Definitely. We definitely need more market intelligence from the Department of Health and Treasury regarding what's happening worldwide in terms of pricing, and to also look at other models that have been used in other countries, like the Australian Netflix pricing model. This was an innovative 5-year agreement between the Australian government and pharmaceutical companies. They paid a lump sum for unlimited 5-year supply of Hep C medicines, and therefore found that they reduced the per patient cost of these treatments by 85%. Patents is an issue, and I know that the next speaker, Fatima Hassan, is going to talk about this a little bit more, but I want to just touch on the evergreening option. And there have been lots of stories or newspaper articles and research done into the fact that pharmaceutical companies tend to increase their medicines by just increasing the price of their medicines by just changing one aspect of the manufacturing and therefore prolonging their patents. Patents were developed for innovation, not for changes in things that happened after things that were launched. And we need to go back and relook at what the patent system was set up to do. We also need to look at out-of-pocket reductions by patients that are on medical schemes. And Salome mentioned that public-private partnerships are an option as well, especially when the patient population is very small, because that does give you greater negotiating power. But there's also other aspects like collaborative country models. In Europe, you have Benelux and the other models that have come together to look at opportunities to be able to collaborate for purchasing and negotiation for high-cost medicines and for small markets within their countries. And they do look at health technology assessments and horizon scanning as well. So they know what they are willing to pay before the medicine is launched in their country as well. The current high prices that exist and the new launch prices are not sustainable for any public health system worldwide, and especially for upper middle income and low middle income countries as well. We need to look at strengthening our pricing policies by looking at other policy options and looking at ways in which we can mitigate unaffordability for the South African population. We need more transparency on pricing approaches and price setting. And transparency is not just about what goes into the pricing components, but about all the public funding that has gone in. And in the public funding, I would also put in clinical trials, because there are pharmaceutical companies that use the South African population for clinical trials, but register their medicines in the US and in the Europe using our population to show diversity and the efficacy of the medication in diverse populations. Yet they delay access in these countries. And Department of Health and the government of South Africa needs to look at policy options where if clinical trials are conducted in this country, then that company is obliged within a period of time to be able to register that medicine in this country. And in addition, I would also say that the patent period at the moment is 20 years, but it should be a global registration of 20 years. So once a company registers that medicine anywhere in the world, their 20-year period starts on a countdown, because it's not fair to come in late to low and middle income countries and then have an extended period there, because it was their choice not to register the medicine in that country. And finally, what is a fair price? At this moment, there are discussions happening at a global level with WHO and pharmaceutical industries and other stakeholders, including governments and other players, as to what is a fair price. And I would ask that you add to those conversations, or you look out for the outcomes of those conversations and contribute to that as well. I will stop here. Thank you very much.
Thanks very much, Fatima. Lots of issues that I think we'll want to pick up in the discussion afterwards. It therefore gives me great pleasure to introduce our next speaker, who is Fatima Hassan from the Health Justice Initiative. Fatima is very well known in South Africa for her contribution to litigation to ensure access, particularly to antiretrovirals. But she is going to speak to us about a legal and human rights imperative to address inequities in medicine access in South Africa. Fatima, over to you.
Thanks, Andy, and just such an honor to be on this panel, and thanks to Salome for not just for the report, but also for organizing this panel presentation, and really humbled to have been asked by her to write the foreword to the report. And I'm sure that for those of you who have the link or who have read the report, you know, after this, you probably feel pretty embarrassed to be part of a global community and to be part of a country where we have such a shameful access situation in relation to cancer medicines, but also obviously in relation to other medicines as well. And I hope that after reading the report, the rage that you feel can actually contribute to some kind of proper organizing in respect of both the pharmaceutical industry and also our own government. So I just want to set a few principles and arguments and make some recommendations in the 10 minutes that I have. The first is obviously the starting point for us is that we've got to look to our constitution. And what does Section 27 say in relation to the right to healthcare access, as well as our jurisprudence has basically informed our law in relation to the right to health also includes access to life-saving medicines. And in the case of cancer, we would argue that that falls within that particular category. Globally, also international law recognizes that to achieve progressively over time the highest attainable standard of health, that has to include access to life-saving medicines. It's not enough just to have access to health services, you also have to have access to medicines. And under international law, access to medicines means 4 things. Medicines have to be accessible, so you must be able to reach it, but it must also be affordable. It must be available, so there needs to be supplies and sufficient supplies. It needs to be acceptable. It actually has to work for the disease that you're trying to treat, and it has to be of good quality, and that's why the regulator plays such an important role here. But it has to be available, accessible, acceptable, and of a good quality on a non-discriminatory basis. And so this brings me to the point that the current set of laws and policies that we have in South Africa and the current situation of the inequity between the public and private health sectors, which Salome in her report very eloquently describes what that disparity means, suggests to us that the laws and policies that we have are actually not translating into meaningful, into equitable access or even affordable access to medicines, given the amount of out-of-pocket expenses that both people in the public and private health sector have to basically undertake. And we're seeing that, the results of that, not just with cancer, but also with COVID in the last few months. And so this unequal divide in South Africa between the public and the private health sector, a sector that only covers about 16% of our population and of our people, means that both in the public and private sector, there are also different treatment regimens that are available and different medicines that are then theoretically available to people. And so that, in our view, undermines Section 27 of our Constitution. It undermines the international understanding of trying to achieve the highest attainable standard of health, because you're trying to achieve it in one sector at the expense of the other. And in so doing, in preventing the ability of people living with cancer in the public sector to benefit from all available medicines that could actually mitigate or treat your different forms of cancer, it undermines not just health rights, but it also undermines dignity. And it also undermines other rights that are considered the bedrock of, you know, civil and political rights in the Constitution. And so this is something that I think as groups and as activists who are organizing around medicine access are going to have to bear in mind about what will be a constitutionally compliant medicine pricing system for national health insurance in our country going forward. And the examples that we've had of COVID in the last year are actually quite concerning and worrying, because there is a concern that in this pandemic, we have given up so much power to the pharmaceutical industry that trying to have a human rights-based, constitutionally compliant medicine pricing system for the future is going to be even more difficult. So globally, if we look at, you know, outside of our constitution, outside of our own domestic context, the reason why it's so difficult to have what we believe is a constitutionally compliant medicine pricing system that doesn't unfairly discriminate between the public and private sector, that makes sure that all medicines that are life-saving are affordable and accessible, and that there's multiple suppliers and there's no supply chain interruptions, is that globally the problem that we're facing, and you know, COVID is the clearest example of that, is that medicines are still seen as a commodity. They're not regarded as a public good in our laws. They're not regarded as a public good necessarily under the TRIPS agreement. So we still commodify it. And I think somebody spoken earlier on the panel about treating it as photocopying paper or treating it as a car or as jewelry. And so part of the problem that we're also going to have to deal with is not just South Africa's domestic laws. We also have to deal with the context in which we operate in, which is the World Trade Organization, the TRIPS agreement, a Doha declaration that in theory offers you flexibilities to use when you have a public health crisis, but which is rarely ever been used because it's actually so difficult to use. I mean, you know, one of the things you have to bear in mind is that in 100 years, Professor Yusuf Alda has written an article on this. South Africa, the South African government, before apartheid, after apartheid, has never issued a compulsory license on a pharmaceutical product. The Doha Declaration has hardly been used. The flexibilities are difficult to use. Even the TRIPS waiver that is being proposed in relation to COVID-19 related technologies for vaccines, diagnostics, treatment options for the duration of the pandemic is being blocked and is being opposed, even though that is permitted within the system of the World Trade Organization. So the opposition, I think, by the pharmaceutical industry and the vested interests that operate amongst a number of companies from Merck to Roche, a number of companies who are making a lot of profit on cancer medicines, not just in South Africa, but elsewhere in the world, is something that is going to make our task more difficult. So all of the recommendations that Fatima's talked about, that Salome's talked about, these are not going to be easy wins. I think it's possible, it's going to be very difficult, but these are not going to be easy wins given the vested interests that we're having to deal with. And one of the things we've seen with COVID is that even though you and I accept and understand and acknowledge that in a pandemic, we need exceptional measures, the pharmaceutical industry doesn't believe in that. So the intersection between business and human rights and the intersection between holding the private sector to account and holding government to account is on two different pages. And we're seeing that also in South Africa. There's hardly any media deep dives into the conduct of pharmaceutical companies, even though Pfizer has indicated that it's likely that it's overcharging us, for example, on COVID-19 vaccines, and that it stands to make a lot of profit in 2021, and similarly other frontrunner vaccine manufacturers. So the question is, I think then, in developing a fair medicine pricing system beyond COVID for the NHI, for the purpose of equalizing our public and private healthcare sectors and access to medicines, in particular in South Africa, is what are the duties of our government to take extra measures to hold this particular industry to account. So let's look at what we currently have. I just want to quickly go through this before I conclude. We obviously have our constitution, and we have some really important jurisprudence that the right to access to healthcare includes a right to access medicines, and that's all of the tech jurisprudence, as well as some of the Grootboom cases as well. The second thing that we could use, and which we have been trying to use, but obviously there are two obstacles that we come up against, and that is Section 8 of the Competition Commission, which has since been amended. And we have, for example, last year, the HAI intervened in a pricing matter where we brought in constitutional arguments and said that our competition law, particularly the provisions relating to abuse of dominance, market exclusivity, patent monopolies, which gives you the right to basically charge whatever price you want, in theory, should actually be subjected to the Constitution and not the other way around, and should be subject to Section 27. And there is a real reluctance amongst competition practitioners and competition lawyers to actually prioritize the rights that are contained in the Constitution over what, the provisions of the Competition Act. And so that is a battle and a difficulty we're having. We also saw that judges on the Competition Appeal Court were a bit reluctant to be able to entertain these arguments. And so this intersection between competition law, patent monopoly laws, the TRIPS agreement, our constitution, and domestic pricing regulation, I think is all going to come to a head when we actually start determining the ambits of the medicine pricing system under the NHI. Within the Competition Commission Act, I said there were two obstacles, and that's what Salome basically mentioned earlier in relation to the inquiry into cancer medicines. The first is that multinational companies, and so this is where we come to the intersection between business and human rights, claim that the Competition Commission in South Africa has no jurisdiction over them. And the second is that they refuse to disclose in full the research and development costs. So Fatima talked about who gets incentivized to have a 20-year monopoly, whose research and development was it? Well, you won't know the full extent of the contribution of public funding or public institution support unless you actually have full transparency and disclosure. And what we believe is that in relation to cancer, HIV/AIDS, COVID, in relation to all of the major diseases where medicines are really profitable, there is a reluctance by the industry to actually share that information, invoking certain legal provisions to prevent that particular disclosure, and that is problematic. Obviously, we've got the prescribed minimum benefits by the Council for Medical Schemes, which relates to only 16% of people in the private health sector. But then, most importantly, we've got two other legs to fall on. The first is, using our own domestic patent laws, which Salome indicated in the introduction. We are waiting. We are basically getting sick, and many of us are dying waiting for the South African Parliament to actually pass the Patent Amendment Bill. This has been going on for years. It's post-apartheid, and we still haven't passed the law that makes us compliant with TRIPS, but in a way which is not excessive. And until we can actually pass that law to make it easier for the South African government to take the necessary measures to reduce the prices of medicine when you're dealing with multinational patent monopolies, then you have to continuously rely on the WTO and the TRIPS agreement and waiver provisions, which we've seen with COVID is not very easy and takes a lot of time. And so there really is an urgency. We've got to support the Fix the Patent Laws campaign to make sure that that bill is actually passed through Parliament. It's really amazing to me that I really don't know what our MPs have been doing for the last year, because if you don't pass this law in a pandemic, then the vested interests you will have when this pandemic is over not to pass this law are going to be even higher. But the second and most important part, and I think this is where our government has failed us, is that our single exit pricing system doesn't have benchmarking. And so the global referencing to what other countries are charging, what other middle income countries are charging for the same medicine is basically precluded. And the Department of Health really has to remedy that, government has to. And what's even more concerning is that Section 21 approvals, and I think Fatima spoke about this, have no regulation in South Africa, and Andy can speak about this as well. So the ability of the Competition Commission or anybody else to regulate a Section 21 medicine or a medicine that's approved under Section 21 is basically non-existent in our law because the regulations have not been passed. And we've been waiting, like the Patent Amendment Bill, we've been waiting for regulations around the global benchmarking for the single exit price, as well as the regulations around Section 21 price controls, which really now need to be expedited. And this suits, I think, the pharmaceutical industry because it means that there's even less ability to hold them to some kind of accountability, and there's less transparency. So to wrap up, there's a few things we have to do. And COVID has shown us that this is obviously very difficult, and there's some kind of deference or fear towards the pharmaceutical industry, which makes it very difficult, and I think as medicine access activists. The first is obviously we need to hold the pharmaceutical industry to account to an even greater level. The clearest example of global access disparities, I think, is the COVID vaccines. And we've seen what patents and evergreening and profit sharing can do, not just in terms of supplies, but also in terms of pricing. both governments and I think media, as well as other businesses, are really fearful of pharmaceutical CEOs and their companies. And we're worried, particularly as the HAI, that COVID is showing that they are exercising even greater power. They are in the driving seat, and that power is going to increase because of the way in which companies have been dealt with or not dealt with in this particular pandemic. I mean, IMEC has just released a report yesterday which shows that Merck, for the cancer drug Keytruda, is not just evergreening patent monopolies and so extending its patents, but it's making, excessive profits. I think in the case of Keytruda, it's about 7.7 billion a year. So it's a very profitable industry, I think, to be in cancer. So if we're going to have a medicine pricing system that is premised on human rights, that is premised on Section 27 of our Constitution, that is premised on international law protections, then I think it has to be a process that is transparent. It has to be a process that is not deferential to the interest and to the vested interest of pharmaceutical companies. It actually has to defer to the principles and to the preamble of our Constitution. And then finally, it's very unlikely that our government is ever going to use the TRIPS flexibilities for cancer. So we are going to have to drive the campaigns to basically insist that the companies not just reduce the prices or be transparent about their pricing, but also that they stop hoarding knowledge, and that public innovation for public life-saving interventions have to be regarded as a public good, no longer as a commodity. Thank you.
Thanks very much, Fatima. Eloquent and absolutely committed as always. Can I ask the participants, if you do have a question, please use the Q&A rather than the chat, and that way all of the panelists will be able to see your questions, and we will try and deal with those in the discussion period afterwards. But we've been building up this feeling that something has to move. Who's going to make the first shift in law and in policy? And this leads us perfectly into our final speaker today, Marumo Nkomo, who is a director in the International Trade and Investment section at the DTIC. And he will be talking about patent law reform, something which has been long awaited and long delayed in South Africa. Marumo, over to you.
Thank you, Andy. And let me take the opportunity just to thank UKZN and the Cancer Alliance for putting forth this very important discussion. I'm going to do two things, colleagues. Maybe just reflect on some of the lessons and opportunities that this current pandemic has brought forth. And then secondly, and I think the latter will be what most people will be interested in, I will just give you a discussion about the patent law reform process, contextualize where the process has been and where it is, and then update you as to where it is currently. So those are the two things that I intend to do in this discussion. And of course, I'm happy to take any questions, and the ones that I'm at liberty to answer, I certainly will. So with regards to the pandemic, I think that from a public health policy perspective, there are a couple of pros and cons. Now, pros, I would say that it's become very, very clear that we need to view treatments not exclusively as commodities, as one of the speakers said, subject to exclusive rights, but we need a paradigm shift where they recognize as public goods, more especially in the context of very significant public sector investments. We've seen, for example, in the United States through Operation Warp Speed, where about $2 billion was invested by the government in order to de-risk the process of developing, one of the vaccines. So that, of course, calls into question the fundamental premise that monopolistic prices are necessary to recoup investment costs where there is a clear and overwhelming contribution by public funds. So that paradigm shift is very important. And I think, colleagues, when we, and I'm glad that there's somebody from WHO here, but when we look at global health policy, these discussions have been discussed or these issues have been discussed for years. And the pandemic really offers an opportunity to revisit important recommendations that we saw, for example, in the Commission on Intellectual Property, Innovation and Health report, as well as the report of the United Nations Secretary General High-Level Panel on Access to Health Technologies. This pandemic that we're in really makes it clear that we need to revisit those. Another important, I would say, positive from the pandemic is that, and I think the colleague from WHO maybe will agree with me, that globally, when you look at the hierarchy of ministries, in normal circumstances, regrettably, we don't see health being, in the top 2 or 3. But I think this pandemic has seen really a rethinking of it, where I think globally the health minister is probably seen as the most important minister. And I think this period offers really an opportunity to have health-related issues at the forefront of all policy considerations. So I think those are important positives, but the negative, and I think that's why this discussion is so important, the negative of the pandemic is that there is a possibility that we lose focus on non-communicable diseases, which really we know, for example, in the context of oncology, is really on the rise. We've seen the incidences that Professor Suleiman made reference to. So this report really from Cancer Alliance is very, very, very timely in that it refocuses us on this very, very critical issue. Now, the report, I think, is very, very good. I've had an opportunity to read the report, and it's quite novel in that it offers a multi-sectoral analysis of the situation in South Africa. And it brings the different role players from the perspective of government actors really under one umbrella and looks at the issues that have to be addressed by the various role players. So I think that's really, really useful. And I've looked very extensively at the recommendations posed to the DTIC, as well as to the DTIC entity, the Competition Commission. And I can say with certainty that we will address those recommendations. So this then leads me to the patent law reform. Now, I think everyone who's tuned in here knows that South Africa's patent regime really needs to be reformed. Many of you have walked a long journey with us. I started in this work in 2016, where I've had the privilege of working with the likes of the Fixed Patent Law Coalition. At the time when I started, Mark Haywood was still at Section 27 and played an important role. His successor, Umunyana Rugege, continues to play an important role. TAC, as well as Médecins Sans Frontières. They've been important stakeholders in our process to reform the patent law. So in 2016, we started a process of engaging with stakeholders to develop an intellectual property policy aimed at addressing the intersection between intellectual property rights and public health. And from that process, we then developed the intellectual property policy. And over a 2-year period, we were able to have that policy approved by Cabinet. And that policy really places Section 27 of the Constitution at the forefront and makes it clear that all our policies, including intellectual property policy, including intellectual property legislation, has to be aligned to the state's obligation to progressively realize the right to health. So all the recommendations of that policy well, most of the recommendations, 90% of the recommendations are aimed at ensuring that intellectual property legislation in this country is much better aligned to achieving the Section 27 constitutional imperative. Now, I think most of you have had the opportunity to read the policy, but one of the most fundamental principles that the policy addresses is South Africa's system of not conducting substantive examination of patents. Now, I think there's historical reasons for this. The idea was that the cost of examination of patents shouldn't fall onto the state and therefore taxpayers. It should fall upon those who've got a direct interest. So hence, the idea was that it would be a more efficient allocation of scarce resources to have a depository system whereby patents are automatically granted. And then those who are directly impacted would then litigate through the Commission of Patents, whereby the process of substantive examination would take place. Now, fundamentally, that is very problematic. And of course, the policy recognizes this and explains that indeed this needs to be reformed. And indeed, the CIPC, the Companies Intellectual Property Commission, which is the implementation agency of the DTIC, really has been preparing itself to be ready to conduct substantive examination of patents. Colleagues, you must realize that the substantive examination of patents is one of the most complex and resource-intensive aspects of any patent regime. This was recognized, for instance, in a 2014 report of the World Intellectual Property Organization. It was also recognized by the United Kingdom Hargreaves Commission, as well as the 2001 United Kingdom Intellectual Property Rights Commission report. It's a very, very intensive process, very resource intensive, and government has really worked very hard to capacitate itself. And we've worked, for example, with the likes of Professor Yusuf Bauda, who's a professor at the University of KwaZulu-Natal, who actually gave a training session to our examiners to sensitize the examiners about public health considerations when looking at patents. So that's one of the key recommendations. Other important recommendations of the IP policy look at how the compulsory licensing system of South Africa really is inefficient because of the fact that it goes way beyond what's required in the TRIPS agreement in terms of the process, not so much the substance, in terms of the substantive conditions and criteria, but more in terms of the process whereby one has to actually litigate in order to be granted a compulsory license. And that's addressed quite substantively in the policy. Similarly, the South African regime around being able to implement the 1997 amendments to the Medicines Act, that is addressed in some detail in the policy. We've also looked at the issue of research and experimental use exceptions, which has a much broader application than just public health. So the policy really adopts a very, very, very extensive approach to the different public health issues. One of the panelists spoke about transparency in the patent process. Indeed, we've in the policy, the issue of third-party observations, pre-grant of patents, whereby third parties can then participate in the process and make information available to the examiners, coupled with post-grant opposition processes that also facilitate transparency in the patent granting process. All of these are addressed very extensively in the policy. And I can tell you then that since 2018, when the IP policy was approved by Cabinet, the department, working with other ministries in consultation with stakeholders such as Fixed Patent Law, coalition, industry, intergovernmental organizations, have been working very hard to draft patent law reform, which is very extensive. Indeed, it would be the most extensive patent law reform that we've seen in this country. And some people may not be aware or may forget that in 2003, there was an amendment to the Patents Act, which was public health related, that introduced what's called the the regulatory review or BOLA exception. That was a public health related amendment that did take place. But this reform that we're talking about is very, very extensive. It fundamentally addresses all of the issues that were identified in the IP policy. It implements all the recommendations of the IP policy and then some. So that drafting process is at a very advanced stage, and regrettably, in a constitutional democracy, in order to ensure that all the checks and balances are upheld, there must be very rigorous processes that all pieces of legislation have to undergo. And so this piece of legislation is undergoing some of those processes. But I do believe that in the very near future, there will be a piece of legislation in the public domain that we would then look forward to engaging with yourselves with to see if there's anything that we've missed. I've read in the report some areas that are not covered, dealing with new technologies, for example, and that's interesting. The proposals that came out in the report, and I look forward to hearing the Cancer Alliance's proposal in the future when the bill is released as to how that can be incorporated. But just to let you know that we are very well aware of the urgency of this. Over the years that I've worked on this since 2016, I had the privilege of engaging with the likes of Tobek Daki, as well as Sue Johnson, who really played an important role in the reform process. And we're very, very well aware about the significant cost that policy that are not aligned with Section 27 can have. So in the very near future, you will see a draft piece of legislation in the public domain, and we remain committed to ensuring that it is given effect as soon as possible with your help. Many thanks.
Thank you very much, Marumo, and thank you very much, Ki, Fatima, and all of our speakers that we've heard, Salome, and all the speakers that we've heard so far. Marumo, we take some joy from your promise of very, very extensive patent reform, the most extensive we've seen in this country, that it's at an advanced stage, and that we will see it soon. I hope that we will be able to hold you to that. Unfortunately, time is against us. It's now 11:23 and the webinar is scheduled to finish at 11:30. But I just want to summarize some of the key points that have come out, and then raise a couple of the questions that we've seen in the chat, and allow each of our panelists between 1 and 2 minutes to make any final fast concluding comments. But I think there's been unanimity across our 5 panelists on certain key messages. These are that cancer is a public health problem, and a problem that is a very serious threat to health, well-being, life, and dignity, and in South Africa and elsewhere in the world, but that cancer can be treated, and that cancer can be beaten, and it need not be a death sentence, and yet it is for so many people. There was really no disagreement from the academics to the public health, to the WHO, to the activists on the fact that there is a problem with pricing, there is a problem with patents, there is a problem with profiteering, and that the combination of these denies people access to life-saving medicines in our country. It was also stated very clearly by Fatima that South Africa is unlike many other countries in that we have a clear constitutional right of access to healthcare services, and more importantly, or as importantly, a corresponding duty on government to act, to take measures to ensure that healthcare services are accessible, and that means affordable as well. But what, again, various speakers, Fatima Suleiman and others, Fatima Hassan, Salome pointed out, is that there are problems with our system of medicines regulation, particularly when it comes to pricing. We heard reference to the single exit price being insufficient by Fatima, not having benchmarks by Fatima Hassan. We heard issues around legislation, regulation to do with Section 21 authorizations for certain medicines, which still, and Salome and I have ample experience of this, will not accommodate access to generic medicines where that generic medicine may be life-saving and necessary and safe, but also affordable. We've heard about issues to do with transparency and accountability. Fatima Hassan said that cancer is a very, very profitable industry to be in if you're a pharmaceutical company, but it's a cancer for patients and for people is a cause still of pain and illness and death because of the way that industry conducts itself. And finally, we heard from Marumo about the processes that government has undergone, that are underway, and the promising news that patent reform is at an advanced stage, but it couldn't be advanced enough and it couldn't be urgent enough. And I guess one of the questions I've been asking myself as I've listened to these 5 presentations is we've been banging this drum for a very, very long time. The Cancer Alliance has been banging this drum for a long time. The crisis of non-communicable diseases has not stood still during that period, but has got worse. And therefore, I guess I'll ask all of the panelists as part of their conclusion to say what needs to happen to get this taken seriously. As we've said, we have a COVID moment where everybody is once again looking at issues of pricing and accessibility of medicine, talking about health as a right, as a public good rather than a commodity. So what do we need to do differently, Salome, Fatima, Marumo, if we are to not have to come back and have another webinar in a few years' time talking about exactly the same questions? Then we have some questions from Linda Grief, which are on the chat line, from Caroline Rich from the Agazi Foundation, concerning the repurposing of older drugs, raising questions about the Council for Medical Schemes and its inefficiency and its inability to distinguish between hematology and oncology. A question by an anonymous attendee about the role of treating providers who are prescribing high-cost drugs and therefore contributing to the problem. There's a huge outcry that the clinical benefits of these drugs outweigh the cost. This is unsustainable, yet so difficult to explain to providers. And Fatima Suleiman said high prices are not sustainable for any public health system worldwide, the high prices of these drugs. We've got comments from Spetlele Gumede from UKZN, which Salome, you may want to comment on, because we've been talking about prices today, but there's a problem with the system insofar as it treats cancer, and accessibility of the system, which Spetlele may be one of the reasons why people present very, very late, and why diagnosis comes so late for so many people. Caroline Rich has further questions, and that really is, I think, a summary of the questions. I want to go back to our panelists, and I'm going to also ask Andy Gray at the end of the closure of this webinar to make any comments or suggestions he wants to make as we wrap up and say thanks. So let's go back to the order we started in. Ki, do you have any final comments or any responses to the questions that have been posed in the course of the webinar?
Thank you, Mark. So I hear calls for broad reforms to improve the efficiency and effectiveness of policy, regulations, and law. Like any other countries, I think reform process won't be easy, and because there are so many interests in our at play. I think but at the same time, I think, you're doing a really great job, and then WHO will stand ready to support any technical requirements in supporting a proper reforms of the system if required. And with regard to your questions about actions at WHO in response to COVID-19, what it means in terms of access to cancer medicines, there's ongoing efforts to ensure the diversification of the supplies through tech transfer and also enhance regional production capability. Of course, now the focus is about COVID vaccines and some of the key health commodities, but I think this will have implications to the production of biological products more generally in 5 years, 10 years time, if we succeed. And I think this is really important for cancers because there are so many biological products. So this is why I'm mentioning about the importance of biosimilar products. I think if we can get it done, I think it will really opens up the access to a lot of the lower income countries. I'll stop here. Thank you.
Thank you very much, Ki. I'm going to go to Fatima, Professor Suleiman second. I'm going to take the Cancer Alliance at the end. So Salome, I'm not overlooking you. Prof. Suleiman.
Thank you, Mark. I think that one of the things we must learn is that we should have a sustainable set of pressure on government and policymakers to be able to get reform done. It's no longer something that we can bring up once a year, like you said. We keep beating the same drum. It's something that we need to raise constantly now, and while the COVID pressure is on, to be able to talk about issues in terms of not having centralized manufacturing anymore by pharmaceutical companies, but having much more technology transfer, like you had said. For me, the other aspect is the fact that we need to be able to bring to attention to payers that they have more power than the pharmaceutical companies do. And we need to change that dialogue where it's now not the pharmaceutical companies dictating to us what it is that they can offer us, but we should be telling them, these are what we need, our needs are, and if you can't meet us, we are going to impose the other imperatives we have in our legal system to be able to meet our needs. And finally, I think that social media has been great in the sense that it's been able to share information about costs of production of medicines, about pricing of medicines elsewhere, and it seems like our National Department of Health and other departments do not have the ability to do market intelligence. So maybe it's time for civil society to step up and do the market intelligence for them. For example, there's a recent research report that's been released on Twitter to say that Moderna and Pfizer, it cost them $3 to make the COVID vaccine. They're selling it to us between $10 and $45. So it's something that we need to keep sustained in our systems to be able to raise our voices. And I'll stop there in the interests of time. So thank you.
Thank you. Thank you very much, Fatima, and thank you for the work that you do. I'm going to go now to Marumo, who I forgot to mention. I see you're going to do battle for us at the WTO in Geneva soon. We will miss you in South Africa, but that's going to be an important battleground for future for ongoing battles around intellectual property reform. Marumo, do you want to add anything to your earlier comments? You need to put your mic on.
Apologies. Yes, maybe I'll just add that although I'll be departing, I am very committed to being available to see through this process. The department, is very committed to this process, and I will still be available to participate. Indeed, in many ways, this process will be getting an upgrade in that Dr. Mustaqim Dagama, whom I'll be taking over from in Geneva, he'll be taking over from me. So I think that you can all rest assured that this will be something that the department and that the government continues to treat with the utmost urgency and priority.
Thank you, Marumo. Good luck. And I hope that you will introduce your successor to all of us before you leave, so that there's no gap, that we have an immediate bridge to keep this up. And if the job doesn't get done, we'll recall you. But thank you for the work that you've been doing on this. Fatima Hassan.
Thanks. So a few quick things. The The first is really we cannot have patent monopolies on medicines that can save lives. And that really has to be the rallying call of all of us going forward. And the second is that medicines and medicine pricing and medicine access really can no longer be subjected to global trade rules. So I think there's a fundamental problem with the way in which the World Trade Organization is designed, and the fact that we're all compelled and forced to use a trade system to try and resolve medicine equity access issues. The second is, even if we can have all the patent reforms in the world and our parliament miraculously actually does something in this year during 2021 and passes the law, it's going to be very difficult to use. I don't think any of us are naive enough to think it's going to be easy, because we've seen in this past year that the tricks of the pharmaceutical industry have gotten more sophisticated. We will be bullied, and the push for transparency is going to be even more difficult. And I think Fatima explained that with the best example around the pricing, or what we call gouging on COVID vaccines. And the third is, whoever's on this call, ask every single politician that you vote for and every political party that you vote for why they support patent monopolies on medicines. I think we need to have a clear articulation of every single political party's position on patents in relation to medicines, especially for life-saving medicines. And then finally, we need a human rights compliant medicine pricing system. If government doesn't introduce one or pass one, we will go to court to compel it to do so. Thanks.
Thank you very much, Fatima. And Salome from the Cancer Alliance to wrap up for the panelists and tell us the way forward, how to fight.
I firstly want to say to every single one on the panel, thank you very much for opening the debate on rethink, redesign, re-engineer. The time is now, not later, now. With regards to cancer services in South Africa, we know that it is inequitable. We know that majority of the patients in the public sector actually come forward with a diagnosis in stage 3, and there's many problems within the system. So the Cancer Alliance, we are hoping that we can release our next report, which we call The Cost of Cancer. And in that report, we're looking at what is the prediction of cancer in the next 10 years and what will be the associated cost. And I actually would like to say that at first, when I saw the associated cost, it was like 50 billion over 10 years. And I kind of like just said, where are we going to get 50 billion over 10 years? Until I read the Auditor General's report that pointed out that the Department of Health spent a whopping 105 billion in 1 year on medico-legal. So we actually have the money in South Africa. The question is whether we have the political will to actually start looking at what the real issues are and not hiding comfortably behind certain things that we have to do. And to a certain extent, the NHI is one of those comfort zones that we've been, you know, it's like a highway. We will send everything to the NHI. No, we need to start serious advocacy and activism debates now. That's the one report. The second report that we will bring out is a very dedicated report where we're looking at the medical schemes and the particular cancer benefits of medical schemes and how that has actually not increased over the last 10 years, or very little if it actually has. And then what are we doing about that? So basically what has been happening is we've been pushing people into out-of-pocket or poverty even further. So the out-of-pocket expenditure has been increasing. And we as the Cancer Alliance are also saying that that very specific research is something that we need to undertake in collaboration with other research institutions what is the actual out of expenditure for public sector patients as well as the private sector patients. So we as the Cancer Alliance, I can also say that with regards to the concept of rethink, redesign, re-engineer, we will start very specific discussions with the various groups as well, because it's not just a matter of we'll have today's webinar, it needs to be focused discussions. We will take that forward, and we then very, very thankfully say to the UKZN and the WHO Centre that we hope that the pricing debates, that we can take that forward and that will shape the discussions even further. Thank you very much.
Thank you, Salome, and thank you for the work you and other cancer activists continue to do. Before I hand over to Andy, just to mention or suggest to people that there's a very important report that everybody should read at an international level of the Independent Panel on Pandemic Preparedness and Response, which I think is critical, potentially a game changer, not just in relation to COVID-19, but to the issues Fatima and others have mentioned about how we treat medicines as a public good rather than something for private profit, and steps that need to be taken to get towards that. And we have to start to look at these issues holistically and together. Spelele mentioned palliative care in her comment, but we have a crisis in this country with access to palliative care services and palliative care medicines, especially for children, where there's been a policy sitting with nothing happening to it for at least a decade. So the complaints we've been making today are perhaps particularly acute and extreme when it comes to cancer, but they're not unique necessarily to cancer. We have a bigger problem that we have to stare down and address here. So from me, thank you very much. I'm going to hand over to Andy Gray for any closing comments that he wants to make on this webinar, but thank you for everybody's participation.
Thank you, Mark, for co-chairing, and thank you again to all of our presenters. I think there's a consistent story which we are hearing here of policies on paper not being translated into legislation and into application. We've said over and over again that we need to look at reference pricing, external reference pricing, at dealing with perversities in the market, at reforming our patent system, at amending our Patents Act, at introducing significant changes into that system. We cannot continue to just say so and trade off of our wonderful history and say, look what happened when it was the drug companies versus Mandela. Look how we faced down that threat. We should be ashamed to trot that out 26 years later. So I really want to emphasize the need now to stop talking and to start acting. Thank you as well to the College of Health Sciences at UKZN and the PR department for their assistance in setting up this webinar. And thank you for the over 100 participants who took part. I hope that we've been able to highlight some of the questions that you raised and address some of those. These are broad-ranging debates, and we could have held a debate of this length on just one or two of those aspects. There has also been a request for the slides that were presented to be shared. We will ask the slide presenters if we can have permission to show those slides, and we will share them either via the UKZN system or via the Cancer Alliance system, and we'll sort that out and communicate it as well. Thank you to everyone. This really is a timely moment to say, let's stop talking and let's start doing something. Thank you very much and goodbye.
Bye.
Thank you, everyone. I cannot say thank you enough.
Well, thank you. It was a success.
I think
Thanks very much to the PR team. Thank you for all your help. And Salome, we'll be in touch around slides and issues like that.
And recording, is there a
It should have been recorded, and we'll get that from the PR.
Yes, I've stopped the recording now, but yeah, it was recorded, and also on our YouTube channel, it's going to stay there forever. So anytime you can go there.
The YouTube link is on the tweet, Salome, that you saw, so you'll see it there. So thank you, Nombuso, as well. Thanks, Salome, and we will talk about other ones. Thank you, Mark, as well. I'm sorry you couldn't get in at the beginning, but I look forward to maybe us doing more in future as well.
Thanks for asking me, and thanks for doing this. I think it was very, very useful. We should have a report on it tomorrow morning that will help carry it further, but great work. Thank you.
Thanks. We'll be in touch in the future for the other ones as well. So thanks a lot.
Good.
Thank you.
Brilliant. Enjoy the rest of the day.
Bye.